Good morning, good afternoon, good evening, whenever you're listening. Joe Davis National University should be familiar to all of you. For those of you that didn't get to meet with us last week for class, my apologies for being so slow in getting this recorded and posted up for you on the Blackboard Collaborate. I'm having a terrible time with Blackboard, and Apple's working on it, and Blackboard is working on it. So we'll see what we have to do for this Tuesday night, because we're going to meet online rather than in class. Anyway, for those of you that missed, here's a review of the things that we talked about in class. You can find this material in the week 1 lecture. You can find it in the text. I just want to make sure that I get the key points across to you, the concepts, so that we're building on this learning about criminal evidence. Okay? Introduction of evidence, what does that mean? Well, that's what happens when an attorney, prosecutor or defense attorney, plaintiff or defendant, but we're talking criminal, says, I want to introduce a shovel, a hammer, a gun, a document into evidence. I want to introduce it into evidence. I want to bring it into evidence, okay? And so the common term is the introduction of evidence. Now, when we look at the term of admissible evidence, that means that it's going to be admitted into evidence by the judge. Okay, now there may be objections by the other attorney. So if the prosecutor introduces evidence, the defense attorney may object to that on a variety of reasons, and then the judge will rule that it is either admissible or inadmissible. And it could be inadmissible for a variety of reasons, of course. The simplest would be that it was an unlawful search and seizure. Okay? The burden of proof in criminal cases, everyone thinks that belongs to the prosecution, and it does. The burden lies on the prosecutor to prove the elements of the offense, and that proof has to be beyond a reasonable doubt. Okay? And we'll talk about a better definition of beyond a reasonable doubt in just a moment or two here. Okay? The judge is the trier of the law. So like I said just a moment ago, when there's the introduction of evidence, it's the judge that will make the decision based on the law whether or not that piece of evidence will be admitted. The same is true throughout the trial. The judge will rule on the law that's involved. The jury will rule on the facts of the case. They're going to listen to the story, if you will, and then vote whether or not which set of facts they believe. Okay, the prosecution. This is a direct quote, but it's legalese so that you get a chance to see it. Don't worry about remembering every word. But prosecution has to establish that the crime or crimes were committed beyond a reasonable doubt. So here's that definition of reasonable doubt. In evidence, a means fully satisfied, entirely convinced, satisfied to a moral certainty. And phrase is that it is the equivalent of the words clear, precise, and indubitable. All right, so that means beyond a moral certainty, that you've established that it is beyond a reasonable doubt. The defense has the burden of persuasion, and what that means is that they have to convince the jury, persuade the jury, that the prosecution did not establish the defendant's guilt. So that if the defense attorney can create in the jury's mind that there might be one other person that did this, or one other set of circumstances, then they're persuading the jurors. Okay, so that's what that means. Judicial discretion, it means that the judge must apply the law, must make a ruling, he or she, and it could be an incorrect one. They get overturned when the case is appealed. But that's what it is. A judge has a legal right to decide on objections. So just like on TV, if you've never been in a courtroom during a trial, you'll hear the prosecution say something, introduce something into evidence, ask a question, and the defense attorney will say, Your Honor, I object, or vice versa. And then the judge has to rule on that objection. Okay, and there has to be a reason for it. And probably one of the easiest ones would be relevancy. That the prosecution wants to introduce a gun and there's nothing to indicate that there's a gun in evidence. Okay, there's no officers testified to search, things like that. The jury is the trier of facts, and they listen to all that evidence, and then they decide which they believe, and then they have to apply the legal instructions. And that becomes key for appeals, where the judge reads the legal instructions. Okay? Inference. An inference is a logical conclusion based on fact or facts. An inference. Logical conclusion based on a fact or facts. A presumption is a conclusion that the law requires the jury to make. They presume the defendant innocent or guilty. Criminal cases come from three main sources. Shouldn't be a surprise to you. Police, they arrest people. A private person's arrest, what's probably incorrectly called a citizen's arrest, and then grand jury indictments. Grand jury, for those of you that are not overly familiar, is where a prosecuting attorney, typically the district attorney, attorney general for the United States, special prosecutor is what we're seeing now, brings forth evidence, witnesses to a grand jury in secret. And an indictment is or is not, may or may not be, is a better way to put it, issued. Okay? And what that means is that there was no defense present. And so the criticism of the grand jury system is that it's a one-sided show, just the prosecution. The positives of a grand jury system is that, yes, it is a one-party show, if you will, where the state, the people get a chance to present what they think is reasonable information. Okay? Fourth Amendment is probable cause standard for us for arrest, search, seizure, all those sorts of things. There is no Fourth Amendment or probable cause for exact standards for what a prosecuting attorney may or may not file. So you may have made an arrest as a police officer, probation, parole agent, correctional officer, and submitted your reports, maybe the investigator, and it goes up to the district attorney, the city attorney, the prosecuting attorney, and the attorney says, I'm not going to file this. I just don't think you've got enough. What's happening there is that there is no standard for the prosecution. You had to have the standard for the arrest, probable cause, but not for whether or not they'll file it. Now, one of the cynical, I think, but probably accurate to some extent, feelings among police or the enforcement half is that prosecuting attorneys only want to file cases they are going to win. The other side of that is that's true. I mean, if you were the district attorney, a deputy district attorney, why would you file cases you don't think you have any chance of winning? That wouldn't make any sense. So it's kind of one of those, just trying to give you a feel for this, how the system works and what goes on. Okay, an arraignment is a defendant's first appearance in court, okay? And that's basically where they get re-advised of their rights. They see if they have an attorney. They make sure that they understand what they're charged with. Okay? That may seem simplistic, but it's also where perhaps the defense may argue and say, my client doesn't understand what you're saying, Your Honor. They're not fit to stand trial. My client doesn't understand what these proceedings mean. So then the judge would have to make a decision on that. Okay, a preliminary hearing is where the judge the judge makes a decision on whether or not there is actually enough evidence to hold the defendant to answer. Okay, so it's really like a probable cause hearing in some respects. All right, the longest preliminary hearing, not a trial, the longest preliminary hearing in the state of California was 19 months. Okay, and that was for the McMartin preschool case. Okay, where it went for 19 months. The Hillside Stranglers case, you may or may not remember that from years ago in the 80s, and that ran for 9 months. Okay, and then the Richard Ramirez, the Strangler, that was 30 court days. Okay, to give you an idea. A plea bargain probably sounds familiar, but make sure that you have a little stronger understanding here. That's where the prosecution and the defense come to an agreement about what they can both feel is an adequate charge, crime, that the defendant's going to plead guilty to, and then whatever sentence is decided upon, and then they take that to the judge. Okay, the United States Supreme Court has ruled that a defendant must have an attorney for a plea bargain agreement. Okay? And there can be no threats or promises in the plea bargaining agreement. All right? Sixth Amendment is your right to a speedy trial. Technically and in base understanding, the only person that can slow down or stop a trial, or delay it, I should say, they can't stop it, delay a trial, is the defendant, that they are entitled to a speedy trial. Now, typically what happens, of course, is that the defense attorney goes along with the prosecuting attorney, and they agree to a later hearing date, something like that, for a whole variety of reasons. I mean, there could be more investigations by defense. Occasionally, you will see a defense attorney stand up in court and say, Your Honor, we're ready to go to trial at the next available date. And that's a strategy. It may be a good one, may be a bad one, depends on the case. But the Sixth Amendment is what says that you're right to have a speedy trial. Relevant evidence tends to either prove or disprove any disputed fact in the case. So to be relevant, it has to prove or disprove any disputed fact in the case. Okay? When relevant evidence is not admitted into court, it could be obtained in a violation of the defendant's civil rights. Why wouldn't you admit relevant evidence? Well, if it's a fruit of the tainted tree, you had no probable cause to stop the car. You had no probable cause to search and seize. You had a warrant, and the defense is going to argue that there was no probable cause or not enough probable cause, something like that, in the warrant. It could be that the evidence is relevant but you can read it, unduly prejudicial due to the emotional impact on the jury. This might be, for an example, how many pictures of a dismembered or murdered person does the jury need to see to understand that in fact the person was brutally murdered? Because theoretically, hypothetically, it would be one photograph. The prosecution may want to show a dozen photographs so that the jury goes, oh my God, this defendant's a monster. The defense attorney is going to argue and say, look, you saw one picture, and what happened to this person is terrible. Get it? Okay, what's material evidence? It's got to be logically connected with some fact that is in issue. Okay, it's important to the case, not merely remotely connected. So it has to be something to do with the case. Maybe a bit of a stretch here, but stay with me. An example might be a defendant's prior criminal history. Does it seem logically connected with some fact that is in issue? That becomes the question the defense is going to argue, okay? Because is it important to this case that 13 years ago the defendant was arrested for possession of marijuana, and today the defendant has been rearrested for possession of marijuana? I don't know, maybe we should make it cocaine. Okay, is there a logical connection? Not merely that, oh yeah, and that's the argument. That's what attorneys do, is argue those kinds of things. Okay, direct evidence proves that a fact without the need for any inference or presumption. Remember, inference or presumption. Okay, direct evidence of a fact is always relevant. Okay, circumstantial evidence requires the trier of fact, remember that's the jury, to use an inference or presumption to conclude that the facts exist. Okay, modus operandi should sound familiar to everyone. That's the method of operation. Circumstantial evidence is admitted at the discretion of the judge. Okay, so you can present all the circumstantial information that seems relevant and it was legally and lawfully obtained. The judge is still going to have the discretion whether or not to admit that evidence. And then on appeal, that might be an issue that the defense attorney would argue on appeal, that it should not have been admitted. Okay? The evaluation of circumstantial evidence, the jury then must decide the credibility of the witness, what inference should be drawn, and then the weight to be given to that piece of evidence. Right? So it's not just you all listen to it and then we all go in and vote. The jury told what facts to believe. A stipulation is an agreement between the opposing attorneys. Your Honor, the prosecution and the defense, whichever one speaks up first, we're willing to stipulate that Deputy Davis is a narcotics expert. We're willing to stipulate that the DNA testing is accurate. Something like that. Judicial notice is where the judge tells the jury to conclude that facts exist. So maybe there seems to be a dispute about it. The judge is going to make that ruling or give a jury instruction, but more than likely it's a ruling and say, this is a fact. You may not think it is, but in this courtroom, what was presented to you is a fact. That's called judicial notice. Presumptions, conclusions, which the law requires the jury to draw from one or more facts. We talked about presumptions, and there are two types: conclusive presumptions, which is the one that we just talked about, and then presumptive judge. Easy for me to say, I'm hurrying. Presumptions that are rebuttable means that it can be divided into strong and weak. There can be an argument over it. Okay? Here are some key concepts that I want to make sure that you understand. Our legal system should not come as a great surprise. Put your thinking caps on, really, to everything you've learned in the criminal justice program, and that is that it's based on English law. Most of what we do anyway. Okay, the rules of evidence are I should back up. There are state rules of evidence and there are federal rules of evidence. In many, many cases they're very similar. In some cases they're not. But bottom line, the rules of evidence constantly change because of new technology. That's the biggest one right away. And so there will be case law to make decisions change. So rules of evidence for both the state and federal courts do change as new situations arise. All right, we talked about the burden of proof, okay? And in criminal cases, it's a reasonable doubt. And we talked about that. Just so you recall, in a civil case, it's only the preponderance of evidence. That's a lesser or a lower level of a lesser degree of proof. Okay, preponderance of evidence in a civil case. Civil cases require a less burden of proof. Okay, we talked about circumstantial evidence already, that the jury has to draw, it has to be related, the jury has to draw a presumption or an inference from that. It's physical evidence, or it's other evidence that's presented in court, testimonial evidence. Okay. Evidence is that lengthy sentence that I read earlier. It's a thing, all right? It's something that can be presented in trial, and it could be witnesses, it can be records, it can be documents, it can be exhibits, it can be a concrete object. Okay, that's what evidence is. Okay, the harmless error rule has to do with the appeal of cases. And the harmless error rule says that if a defendant is going to appeal the court's decision, the jury's decision, and it wouldn't make any difference even if they won. They go up on appeal and they win, but it doesn't change anything in the facts of the case, then there's no reason to file that appeal. It's the harmless error rule. Okay, the jury's responsibilities, we know that they have to listen to the judge's instructions, the evidence that's presented, and then apply those instructions. That's why they can't take their phone in there and Google what they want to see. The judge's responsibilities are to decide if there are questions that should be allowed and rules on objections made by the lawyers. Okay. The referee, almost, if you will, the one running the show, the band leader. Okay, reasonable doubt, beyond a reasonable doubt. Remember, for criminal trial, beyond a reasonable doubt, and that goes back to fully satisfied, entirely convinced, satisfied to a moral certainty, all those kinds of things. Okay, an affirmative defense. There are situations where a defendant has an affirmative defense, and that would be self-defense. Would be an affirmative. They have to. The defense attorney has to assert that. Remember, we talked about affirmative things. The burden of proof in this case would lie with the defendant to say, wait a minute, this was self-defense. That's an affirmative defense. Okay. There are other examples. We won't mess with them. When you appeal to a higher court, that's what's called a direct appeal. And there are always exceptions where cases go straight to the U.S. Supreme Court. Don't worry about them, okay? The appeal that we're worried about is called a direct appeal. You go directly to the Court of Appeals, and remember, it's not guilt or innocence, not really the outcome. Always exceptions to that. But what it is how the game was played on the rules of the trial, if you will. Voir dire should ring a bell to some of you, if not all of you, because that's what happens when a witness is on the stand. Typically, the law enforcement person, the criminal justice expert, and they get to ask you about your training, your career, and all of that. That's what it is. That's what voir dire is in a courtroom. But what does voir dire mean? It means to speak the truth. That's the translation. Okay. Now we also know about the Sixth Amendment, right? And that's the right to a speedy trial of one's peers. Okay, and that should ring a bell to you. Modus operandi we talked about. That's the MO. That's doing the same thing. We all have an MO in life, whether it's to put off doing our work or doing it early, those kinds of things. Okay, relevant evidence, we talked about that. It has to be able to prove or disprove any fact in a case. Okay, direct evidence. Direct evidence does not require an inference or a presumption. Okay, it proves it just as it is. Circumstantial evidence, kind of a review here, indirectly proves a fact, where direct evidence directly proves a fact. And then testimonial evidence should make sense to you. That's where someone under oath or affirmation actually testifies to what they saw, heard, or know. Okay, I hope that helps. Tuesday night this week we are not going to meet in class. We only had 4 attend. There are only 7 enrolled. So I'm going to do it online with Blackboard. So we will meet at 6:30 online Tuesday night, and I will send everyone an email with that. If in fact it's not on Blackboard for some reason, I'll let you know. Okay. Hope that helps. Keep the cards and letters coming, and talk to you next week.